Justice Henry, Justice Kagan, Justice Gorsuch?
You know exactly what I'm going to ask you. The government acknowledges that there's a presumption that we're not doing our normal statutory interpretation here. There's a presumption against 2 punishments for 1 double jeopardy offense. Where does that come from?
I think it is largely a factor of the courts presuming that Congress generally doesn't intend to authorize cumulative punishments for the same offense under Blockberger.
Why do we presume? That's just repeating the words back to me. Why? Why do we presume that?
I think originally there were some early cases that did suggest that under the double jeopardy clause applied to cumulative punishments as well, and so there was this form of constitutional avoidance. In later cases, the court made very clear that the constitutional analysis and the statutory analysis collapse into one another. As long as Congress has in fact authorized it, then that's fine, and we think that that's sufficient.
All right, let me stop you there and just say, I think you've got 2 possible answers. One is lenity, which is rooted in the separation of powers and the presumption of freedom, of liberty. And I took that to be Mr. Larson's answers after a while. The other answer is it might come from the double jeopardy clause itself, which after all says you cannot be punished twice for the same offense, in which case it's not a presumption, it's the law. Now, I know we said it's a presumption in Hunter, but Hunter was back when we were treating Blockberger not as authoritative under the double jeopardy clause, but as a tool of statutory interpretation. We've rejected that sense in Dixon. We overruled Grady. And since then, we've said in Shiro and Pierce, you can't have 2 punishments for 1 crime, 2 sets of punishments. Now, of course, a punishment might include a term of imprisonment and supervised, yada, yada. But you can't have 2 sets of punishments for 1 crime. So we've spoken out of both sides of our mouth on this. Would you object to a footnote at least acknowledging we've spoken out of both sides of our mouth on this and applying the presumption anyway?
So we certainly don't object to applying the presumption as the court has done in all of these cases. I would push back a little on the idea that we think or the idea that this is compelled by the double jeopardy clause
or at least
itself.
our precedents. I mean, would Pierce and Shiro say it?
Sure. I think if you were going back to original principles in the double jeopardy clause, it actually—
You might be shocked to hear I'm interested in that.
I am somewhat unsurprised, but it does refer to being twice put in jeopardy of life or limb, not
the same offense.
Yes, for the same offense, but Congress, of course, can define offenses however it chooses to do so. It can also define punishments. So
once you got 1 offense, you get 1 set of punishments is the natural conclusion from that text. And we have said that twice.
I think what Justice Scalia said when he was looking at the original meaning of this is that, in fact, the double jeopardy clause should apply to successive prosecutions, but not to cumulative punishments.
I agree with that, right? And his point was, well, there might be multiple punishments for 1 offense, and that's fine. And of course, fines, imprisonment, supervisory. But what is a successive prosecution? Through most of our history, you couldn't have a successive prosecution. There was no joinder of offenses. But now there is, and we use Blockberger to tease it out. And here we have, as you concede, 1 offense. 1 offense. Forget about J and C. There's 1 offense. Why isn't the natural implication, again, and I'll leave you alone after this, I promise. The natural implication in our precedents that say you get one set of punishments, the obvious implication, or at least we should acknowledge the tension between our cases on this, which speak out of both sides of their mouth.
So I don't think we would object to any kind of footnote that suggests something like that could be revisited in future cases in which the issue was briefed, but we would encourage the court to continue to adhere to the precedents that do apply the Blockberger presumption and that do acknowledge that Congress has the authority to punish in this way.
Thank you, Ms. Brown.